Your Honor. There is one other issue. The defense then would have Scott Tomes as a witness, but apparently he's unavailable. I have him under subpoena. The timing of his unavailability is suspect for me, but...
Oh, Scott Holmes! Was that her only witness?
I conferred with the prosecutors, and they've advised that he is simply not available. So what we talked about was talking about potentially some agreed facts that could be presented to the jury. It's an unusual situation for me to be in, but, as a lawyer, when you issue a subpoena...
Hi, Nacho.
People are expected to appear. So I'm caught in a difficult spot.
Yikes.
So you can address it to me when you come back at 1 o'clock, okay?
Okay, thank you.
Judge is like Judge Petty. I want to have my lunch break now. Fuck off. Let me eat my lunch first, and we'll think about it.
Be seated. The state has rested then. Mr. Freilich, the case would then turn to the defense. Do you intend to call witnesses, or want to address me on the stipulated facts?
Yes, before I do that, Your Honor, I'd like to make a motion for a directed verdict. Ask that the court consider...
For a directed verdict? What? Is he saying the state didn't present their case?
Use the microphone.
Oh, sorry. Ask that the court consider that as it relates to the first-degree intentional homicide count, I would argue that there is insufficient evidence to support that particular charge. There's insufficient evidence to show that my client, Taylor Denise Schabusiness, had any intent to kill S.T. Schabusiness. What we have here is some testimony from a number of law enforcement officers. We also have some video footage from an interview between my client and Detective Groff and Detective Kempf. It's clear that my client likely did consume and ingest methamphetamine with Mr. Therian.
Okay.
Prior to his death, my client provided commentary and answered questions from Detective Groff. I would submit that
He wants a judge to basically fuck the jury and just say that he wants the judge to say that there's not enough evidence that the state presented to show that Taylor Schabusiness is responsible for the charges and stuff like that. So basically, like, we don't need the jury to make their decision. I think at this point, there's not enough evidence. That's what he's saying.
she indicated that she had no intent to kill. The question is, did my client do it or not? That's another question. There are a lot of different issues here going on, but based on what she said to the detective, I'd ask that the court consider dismissal of the first-degree intentional homicide charge.
The judge's face.
On the grounds that there was no intent to kill. Also, there are really no eyewitnesses to whatever went on in the basement at 829 Stony Brook Lane in Green Bay. When Tara Pakinich and Stephen Hendricks went downstairs, they didn't find anybody down there. They found body parts, unfortunately, but they did not find my client there. My client was at 2353 Eastman Avenue, and that's where she was arrested. And there were no body parts over there. There were body parts in a van that was owned by Scott Tomes. That's not my client's minivan, that gold.
Oh my God. Oh, that's not Taylor Schabusiness's car. That's someone else's car.
Town and Country Chrysler minivan belonged to Mr. Tomes. So there are a lot of issues here. As to the third-degree sexual assault charge, the state's got to prove that my client had sexual intercourse with Chad Therian. I believe, based on this record, in the video, there's no evidence to show that my client had any kind of penis-to-vagina contact with Mr. Therian. We have testimony from the DNA expert that indicated it was uninformative as to the dildo. And I know that my client claimed that.
But she admitted it, though. She admitted to using the dodo on Chad.
Dildo was used on Mr. Therian, but there's no DNA evidence on that. And so I would ask that the court consider dismissal of the third-degree sexual assault charge as well for those reasons. Thank you. And finally, as to the mutilating a corpse, count 2.
The gall.
Again, there are no eyewitnesses to observe what happened in the basement on the dating question. So for all these reasons, I'd ask that the court consider the motion for a directed verdict and dismiss these charges.
Mr. Saunders.
A reasonable juror viewing the evidence in the light most favorable to the state could convict. The state's met its burden. His motion should be denied.
Okay, well, these motions are fairly common in cases like this, and
yeah,
the court does have to, in these circumstances, look at the evidence in the light most favorable to the non-moving party. This is by no way the court making a decision about what the ultimate verdict in the case will be. That's up to the jury, not up to me. But the court's task at this point is to take a look at the four corners of the record, the evidence, to see whether the state has satisfied their burden of proof, at least to this point, such that the matter can move forward and be given to a jury. Each of these counts has 2 elements. The homicide count has 2 elements. The mutilating a corpse count has 2 elements, and the third-degree sexual assault count also has 2 elements. And the court is satisfied when considering the entire record in this case that a reasonable jury could conclude that the state has met its burden and convict based upon the evidence that has been offered thus far.
Yeah.
Again, I'm to look at the evidence in the light most favorable to the non-moving party. That isn't necessarily how a jury will look at it in their deliberations, but that's what I'm to do at this particular point. And in doing so, I'm satisfied that these motions for directed verdict should be denied, and that's what the court does at this time. So those motions are denied.
Sorry, Mr. Frolic.
And so I'm going to turn back to you, Mr. Freilich. My understanding is, as a result of Mr. Tomes not being here due to some health issues, that there's been a set of stipulated facts.
Yes, Your Honor, but before I do that, I know that my investigator had made attempts to contact Scott Tomes as part of the defense investigation in this case, and there was
Wait, is his name Scott Holmes or Scott Tomes? I can't tell if the T is a carryover or if it's Scott Holmes.
Investigator was not successful in making contact. But
Yikes.
we did get a subpoena out, and the Brown County Sheriff's Department, I believe, subpoenaed Scott Tomes for court as a defense witness. The prosecutors did inform me promptly that he is not going to be available. Maybe he's got health problems or hospitalized, but they told me that he is not available. I've advised my client of this. I find that, and I'm not blaming the state, but I'm blaming him, that the timing of this seems suspect to me, that he's not available. I haven't seen any report, doctor's note, anything like that. So before I answer the court's question, I'd ask that the court consider a motion for mistrial because this witness is not here. Has been
Oh my God. How many times does the word mistrial come out of this guy's mouth? Oh, dude, come on.
subpoenaed, and I really have no recourse to call him and question him about the issues in this case. So I'd ask that you consider that motion.
Well, before I turn to the state and ask for their response, Mr. Freilich, what can you tell me? What was your expectation of what he was going to testify to?
Well,
Oh, this judge. Tell me, Mr. Frelick.
I have some highlighted sections from his statement that the state and I agreed on
Okay.
as to what his testimony would be about. But, when you call a witness, there may be other things that come up. But I'm working off the statement. I've highlighted the yellow parts that would be told to the jury if the court.
Hey, Groovy Goose. No, I don't stream simultaneously on Twitch. On Twitch, it's mostly just gaming and then YouTube React stuff. And then on YouTube streams, I just do true crime stuff on here. So different types of streaming stuff going on there. But yeah, if you have a Twitch account, go ahead and follow. It's the same username.
Felt that was appropriate. But I felt the need, because I'm at this kind of crossroads with this kind of problem, that I would make this motion first.
Okay.
Sure. But I don't think you have my question, because the question is you've asked for a mistrial based upon the unavailability of this witness. So the question is,
Yes.
what was he going to testify to
Yes.
so that I can assess the
Mistrialness.
gravity of his not being here?
It's not a word.
I understand. Okay, thank you. I believe that he would testify that on that Monday night, I believe that would have been February 21st of 2022, that that Mr. Therian and Ms. Schabusiness came over.
Okay.
He did not know Shed's last name, but he
Okay.
saw him before. And that he believed that they hooked up to get some meth or do meth. That would have been about 9 p.m. on Monday night. And that he had this gold Chrysler Town and Country minivan, and his
Okay.
keys were on a lanyard, which hangs on a hook by his front door.
Okay.
And that he indicated that Taylor Schabusiness has used his vehicle in the past, but with his permission, and that she's always asked to use it.
Oh my God. Is he going to say she never asked for the van, therefore maybe she never used it?
And then he said she did not ask to use the vehicle last night, and that he did not give her permission to take
Call me Miss Cleo.
the vehicle. And he said he did not call the police to report the vehicle missing. And then he indicated that he was drinking some whiskey and cranberry juice, and that he sometimes gets drunk.
Wait, whiskey and cranberry juice. I've never heard of that mix before. Oh, do you have a UTI or something like that? I've never heard of whiskey and cranberry juice before. Is that a thing? What do you call that?
But not inebriated. He indicated around midnight, Ms. Schabusiness returned home with his vehicle, and she went basically directly to her bedroom, that he had a suspicion she may be high on drugs, and that he believed the police arrived 15 or 20 minutes after Ms. Schabusiness got home. And then he talked about the living arrangements in the apartment, and that Ms. Schabusiness stays in the bedroom and he sleeps in his chair in the living room. So.
No, certainly, Tam. I do feel bad for the lawyer too. But we making jabs over here. The lawyer, it's a public defender. He has to defend her. Unless there's something that arose that was like a conflict of interest or anything like that. Like this is part of his job. So, yeah.
Okay. So first thing I want to take up is Mr. Freilich's motion for a mistrial based upon the unavailability of Mr. Tomes.
I think the motion should be denied. Essentially, everything counsel stated, the state is willing and has prepared a stipulation to that effect. So I don't think that a drastic remedy of a mistrial is necessary. I do want to be quite clear. The state does not control Mr. Tomes. We in no way hold him to disregard a defense subpoena as part of our case. We chose not to call him. We were advised about the medical issue, and we passed that information along to defense counsel. So I don't want it to
Because we can criticize what he does in trial, but if people went out of their way to harass him, then yeah, that's some fuck shit. Don't do that.
This record that we are
You guys wouldn't do that because you guys are cool. Thank you for the follow.
influencing his unavailability in any way. Obviously, counsel can still attempt to have him here and still attempt to produce him. It's an issue the state deals with fairly regularly in trials. That isn't being done, so I don't think the defense failing to produce a defense witness is grounds for a mistrial, particularly when the state's willing to stipulate to everything the defense seeks to elicit, essentially.
Your Honor, I want to let the court know that Mr. Saunders promptly let me know of this situation as soon as he found out about it, so that was appreciated.
Oh,
I don't want all the details, but as far as a medical issue, I mean, if you have a bad cold, that's a medical issue. If you are in the hospital for serious surgery, that's a medical issue too. Is he incapacitated? Is he just staying at home because he doesn't feel like getting out? Do we have a sense of that?
I think the latter. The information we received is that he was in hospital and would be for several weeks.
Oh.
That was the information we received from a relative.
That's okay.
Well, so in front of me then is a motion for a mistrial. A number of things. First of all, when I listened to the recitation of the information that Mr. Tomes was going to testify to, first of all, I'm satisfied that a lot of that information has already been testified to by other witnesses, particularly the individual, the mutual friend
AJ?
of Mr. Therian's and Ms. Schabusiness, who was here yesterday, testified to some of the events that occurred at Mr. Tomes' apartment. Frankly, some of the other information that Mr. Tomes was going to be testifying to that was referenced by Mr. Freilich, I think was brought in through some other of the witnesses. The information about what Ms. Schabusiness did with Mr. Therian while they were at Mr. Tomes' apartment. There was reference to potentially utilizing controlled substances there, that perhaps Mr. Tomes was in either a different part of the house or had his gaze focused somewhere else while they utilized controlled substances behind his back so he didn't see. That kind of information has come in other areas. Really, the only piece of information that I heard that doesn't sound like it came in any other fashion, except by indirect statements from Ms. Schabusiness in her interview with law enforcement, was the comment that when she used his van in the past, she asked permission, and that she didn't ask for permission that night to use his van. And there's a couple of things about that particular piece of information. I remember the information in the video where the detective was asking her questions, and she indicated in response to her question, I don't know if he knew that I was leaving or not. I don't know. I think she was uncertain whether Mr. Tomes actually knew that she was leaving. And the reality of it is, if she was utilizing his van and she was uncertain whether or not she even knew about it, whether or not he even knew about it, then that might confirm a statement whereby Mr. Tomes says, yeah, she usually asked for permission, but that night she didn't. That would be very consistent with what she reported in her interview. Beyond that, I'm not really sure the extent to which that piece of information is so relevant, that his presence is needed here, as opposed to stipulating to the facts that are outlined. For all those reasons, I'm satisfied that the fact that he hasn't responded and arrived here today due to medical reasons, I'm not going to grant a mistrial for that reason. I am then going to turn to the parties to determine if there's anything else that needs to be recited regarding that stipulated set of facts, or whether, Mr. Freilich, you've actually gone through and recited it there. Is that what you would intend to have recited?
Mr. Saunders has it, Your Honor, so I'm just going to take another look at it real quick.
Take your time.
At some point during the defense case.
Sorry.
Gentlemen, how do you want that submitted into the record?
I can mark it and then.
Wait, hold on. What did he read?
And what I did was highlighted in yellow the relevant sections from the statement he gave to police, and then Mr. Saunders' office had it typed out, so it's in proper order.
Oh, okay. Doesn't read it out.
Thank you. That's the only one, and then the only issue is whether your client's going to testify. Then how we'll proceed is I'll bring in the jury, I'll read in these stipulated facts, I'll excuse the jury again, and then I'll have the colloquy with your client about her testimony. So can you give me a sense, do you have other witnesses?
Your Honor, I've looked at my list here. A lot of the witnesses I was going to call have already been called, so I think we're good. I will need some additional time to confer with my client on whether she wishes to testify or not, but
Okay.
that's where.
All
She's
the
not
other subpoenas
testifying.
that are out there, we'll break for a little more.
Okay. Dude, imagine if she testified. Whew.
Right,
The judge's
like,
gonna let
is
her
that
know.
You decided that you would like to exercise your right not to testify. Is that correct?
That is.
Okay.
Wait, that's her voice? What the? That's her voice?
You've decided that you would like to exercise your right not to testify. Is that correct?
That is.
Okay. Now, I know you've spoken with your attorney. Do you feel you need any more time to talk?
Wait, weird. It sounds so different from maybe because like the interrogation videos are so like shitty or something like that. Oh my God, that was like so high pitch.
Talk to your attorney about that decision.
No, I did not.
Has anybody made any threats or promises to you to get you to make that decision here today?
No.
Okay.